legal problem if you get the opportunity. Because anybody that can beat the United States government on a passport issue at the local court, in federal court on the first round, has obviously learned something about this legal system. Y'all want to take the lawyer test? Name the law school dropout. Patrick Henry, author of the speech, "Give Me Liberty or Give Me Death," tried 1,000 cases before he was 31 years old. John Jay and John Marshall, two of the first 4 Chief Justices of the United States Supreme Court. William Wirt, Secretary of the Treasury in the first 3, somewhere in the first 3 or 4 administrations of the United States government. I think Wirt was also a signer of the Constitution and the Declaration of Independence. Roger Taney, Justice, United States Supreme Court. Daniel Webster, codifier of the American Language Dictionary, Secretary of State, 1840 to 42. Salmon Chase, Justice, United States Supreme Court. Abraham Lincoln and Stephen Douglas, Senator Stephen Douglas, President Abraham Lincoln. I'll give you a little aside. You know what the Lincoln-Douglas debates were? Lincoln spoke extemporaneously for 90 minutes. Stephen Douglas rebutted for 3 hours. Lincoln rebutted for 90 minutes. I submit to you quite candidly that Ross Perot, George Bush, Bill Clinton, Bob Dole, and all the rest of these goombas, except perhaps with the exception of Pat Buchanan, probably couldn't elucidate on anything of any worth for over 9 minutes. That's how the Lincoln-Douglas debates went. Clarence Darrow. Robert Morley, the chairman of the American Bar Association 1953 to 1954, and Strom Thurmond, who I believe became a lawyer sometime around the time of Ezekiel and still sits in the United States Senate today. Patrick Henry, John Jay, Marshall, Wirt, Taney, Webster, Chase, Lincoln, Douglas, Darrow, Morley, or Thurmond. Name the law school dropout.
Darrow.
All of them, or Darrow. See, I'm preaching to the choir. Chicago attorney Clarence Darrow, the name most closely associated with the aggressive defense of the disenfranchised and the dispossessed, was the law school dropout. Clarence Darrow studied law in Chicago for 1 year and dropped out of school. He went to the library and he trained himself. He took the bar and passed. He went through the screening committee process and passed. He paid his $5 fee, and sometime during the last decade of the 19th century, he was admitted to the Illinois Bar Association. You see, you have been violently deceived. The other gentleman in our test never went to law school. Now, you can decide if you'd want Patrick Henry to aggressively pursue and defend your rights, or one of the lawyers from the Watergate era. Remember those 20 goombas who surrounded Nixon? Nixon, all the lawyers will appear on my hand. Nixon, Mitchell, Haldeman, Ehrlichman, Colson, Magruder, Liddy. I think only John Dean was not a lawyer. And that's where we are. All public school trained. As Dwayne says, all public fool trained. That's essentially where we're at. If you want to know exactly where you're at, as I get ready to go over to the book table for our crazed and crass commercial message, in 1995, in the state of Texas, it's the Uniform Commercial Code. In 1840, it was called the Negotiable Instruments Laws, east of the Mississippi. Texas probably didn't have a lot to do with that in 1840. In 1600, it was called Corporate Capacity in a Regulated Enterprise in the British Empire and Commonwealth. 100 years before the Messiah came to earth, it was called the Roman Law Merchant. 2,000 years before that, it was called the Babylonian Commercial Code. commercial code went from Nimrod in Babylon to Rome. As you heard Michael teach you yesterday, when they codified the common law in England some 500, 600, 700 years ago, that corrupt moron who did it simply cabbaged the 12 tables of the Roman Empire, that is, the Babylonian commercial code, and bolted it up as the common law of England. The seeds of our trouble are laid at that point. We are now going to swing to your right and my left. And
table of contents that starts off with trial preparation, which is exactly what you should do. And it, strange enough, advocates that you write your closing statement at the beginning of the trial. So I need this closer. So it'll tell you in no uncertain terms that how you set up the case is determined by your closing argument. So your closing argument is what you're going to be doing all the way through the case. It selects out such things as a log for judges. So if you have a working relationship with the judges, you'll keep an inventory on him. The prosecuting attorney. For instance, I've had one prosecuting attorney in a local county that has never successfully prosecuted a case against anybody I've worked with because he makes some fatal errors. Usually he engages in argument with us and we call him as a witness. And of course that you obviously can't be the witness and the prosecuting attorney. So there are several things depending on your point of reference. Now, what Erwin Rommel is about is prosecuting, and primarily 42 United States Code. So there's a different procedure for defenses than there is for what we say offensive. Now, in most cases, if you're following similar to this trial book, it'll walk you through, let me see, case planning. For instance, it'll walk you through legal research. Along with legal research, you're going to meet and greet various actors in the courtroom, and they'll tell you plainly that this is a stage, and that everything you do is staged for the jury or the judge in some cases. But if you're prosecuting, you definitely do not want to upset the, what we say, conditions not in your favor. If you're defending, there's a different set of rules. So what we've tried to do is develop a book similar to this. In fact, you could literally reprint this book, and then, for instance, at the end of every chapter, they tell you how to avoid mistrials. And if you're a defense, of course, it's how do you cause mistrials. So it goes hand in hand. You have to know where you're at and what you're going to do. So what I was going to do is, for this particular presentation, is give you an idea of what you can do if you've got the book. So well, I'll just choose this out of this particular one, legal objections. I think you've heard us say that there are 38 legal objections. If you were going to know how to make those objections, and you're in the courtroom, course, counsel. So in this book, it sets it up in an outline form. It tells you all the legal objections and where to find it in this book. So 28 U.S.C. is dovetailed into this thing. In the back of it, it also cross-referenced it so you can find it easier. But if you're presenting opening arguments, there's a limited amount of objections you can make. If you're doing closing arguments, there's an increased opportunity to abuse, what would you say, facts and law that weren't introduced. So you'll often hear most of the, what we say, misstatements are at the end of the trial. Now, there's a reason for it, but nonetheless, this tells you how to object to it and how you set it up. So you can actually set it up that these people will misstate the law, and now you have an objection. Or you can close your ears and not pay attention and let them have control of the courtroom. My observation has been if they're listening to you, you're obviously in control of the courtroom. In any event, how to avoid mistrials is what we were concentrated on. So it would say in here, in order to preserve an issue for appeal, it must be placed on the record. So this is the reason for objections. If somebody's leading a witness, it's procedural, it is not grounds for mistrial. If somebody is misstating the law and you object or fail to object and the jury takes it to heart, you lose, and there is no procedural due process violation. If you object, it's considered on the record. So it's one of the things that you need to do. Now, how many of you belong to a law school or some regular meeting format where you can get together? So there's a few in here. What we did at my place was set this thing up as the workshop primer. So every time you came in, we had basically the 20 positions that a courtroom takes, including the 12 jury members and the alternates, and you would get to play a different role every time you claimed the class. So you get to see how making and meeting objections, which is one of the books we sell, is improvised in the courtroom. Now, it sounds strange, but if you just did this 3 or 4 times, you would be better equipped than most lawyers. Most lawyers never see the inside of a courtroom. They're paper shufflers. So they don't get to stand up and make objections, and they don't get to do anything other than by paper. So if you had 3 experiences in front of your peers, you'd have more experience than most trial lawyers. In any event, if you wanted to cause a mistrial as opposed to avoiding one, then you have to unread the circumstances. So it says in order to preserve a condition for appeal, you have to make it on the record. All you have to do is fail to make a record of it. It's a failure of most individuals. They're afraid to be held in contempt or whatever. Okay, so it says you can't breach courtroom decorum. Now that's true to a limited extent. Most individuals who are not familiar with the courtroom, what we say, are intimidated and do whatever they're told. If we're defending again as opposed to prosecuting, our position is that you do what's necessary to keep their attention and to cause the trial to come favorably in your way. For instance, you put a witness on the stand and you're cross-examining, and the prosecution's or whoever your opponent is continually interrupting you because of the formation of the questions. You can literally have him do it in a dialogue form. So he just conversational style, if you will. So you let him say what's on his mind. Now, it can be a mistake if you have an experienced witness, but sometimes the policeman will just upchuck everything. In other words, I was going down the highway and we saw this car that looked suspicious. All of that would be objectionable if you know how to object. I have a gentleman I work with who's he's family farm advocates that literally stopped the courtroom. In other words, there's 5 hours of testimony in which 3 questions are answered because he knew how to formulate objections. So I mean, that's pretty astounding to me. And basically all they got was his name, or the name of the witness, and where he lived. Everything else was without foundation. So if you're doing it right and you know how to formulate this, it works very well. The mistrial comes about when you happen to be prosecuting and you do something that's, what we say, inappropriate and prejudices jury, and they'll just call a mistrial on you. So, you know, it works against you either way. I would suggest that if you get a chance to get into a trial, to view one, just go in and sit and watch. And most of the attorneys are very boring, and so you're not going to see anything that goes on. But if you listen to what isn't said, then it gets to be interesting. We have, I would say, a case currently going on in Minnesota in which an individual is charged with not giving a breath test, which is a crime in most states now. And I think in this state, not giving your name is one of the bigger ones that we're hitting on. Yeah, we have a couple of them in here that have been charged with not identifying themselves. In any event, if you know how to use the constitutional provisions on it, in other words, the right to remain silent, this has been very effective. All of the trials that we're involved with currently in Minnesota right now are criminal, so there are no civil ones going. So most of what I do is defensive as opposed to prosecuting. Let's change this thing back. I wanted to get into the formula for this thing so you have an idea of what they're going to do in it. I'm trying to get people to buy this book, by the way, not with us because it's not available from us, but from West Publishing Company. But let me give you an idea of how they say on just jury selection. So if you're ever in a trial, and most of you are going to be sooner or later, the first thing you're going to have to know is, besides courtroom procedure, is how do you select a jury. In the federal system, it's usually done by the judge, and he'll voir dire the jury, which leaves you absolutely nothing to do except write questions that you want the judge to ask. Now, it's a violation of due process, in my thought, to make the judge or allow the judge to ask the only questions. Because how do you ask a man if he's pregnant? And if the pregnancy would affect his ability to sit on the jury? And then how long he's been pregnant, etc. So obviously there's some questions that a judge can't ask, or if you will, you can't get a correct response. If you have ever been involved, let's say, with a police officer asking questions, it's not unlike that to voir dire. So what you're looking for is biases and prejudices and what we say characteristics. Somebody with a facial tic may be totally annoying to you. It may be that you can use that also against him, but those conditions, if you're involved in a car accident, somebody with a facial tic is what you want to keep because he's aware of what an injury with a long-term effect has on you. There'll be police officers or their wives, or county officials or their wives that'll be on the jury. They may or may not be good for you. You have to know all those things. This thing allows you to do that, this book does, by making a formula, or I should say a form, in the back of the chapter for each aspect of it. I don't have this thing marked because it's a new book to me, but basically it's a jury selection chart. And voir dire is, I mean, you're going to get what you take, but the voir dire is the one chance you have to determine who's going to judge this case, whether you're defendant or the prosecutor. So you can ask them such things as opinions, attitudes, attitude about the law, other problems. In other words, some people don't like being confined at night. If they don't like being confined and you have something like the O.J. Simpson trial, they're going to be confined and they aren't going to like it. They may use that against you. How you smell that out is more fun if you know what this is all about. So most lawyers fail miserably in juries. We usually ask for the jury wheel, which is how the various counties pick juries in our area. They're picked because they have driver's licenses and they're registered as voters. That's the criteria in our area. So if you didn't have a driver's license and you were charged with no driver's license, you could not get an impartial jury. So one of the conditions is that you have a driver's license. So it's those sorts of things that you're looking for. You would be asking whether or not the members of the jury like your client. Now, if you're prosecuting your own defense, then it's sort of hard to say, well, do you like me or dislike me? So those sort of things are a handicap, which is the reason that the next subject when we do counsel will come up, because you can now use counsel and compel that assistance as opposed to these people being able to deny it and what we'd say relegate it to the realm of the professionals. You, on these sheets, rate jurors. So you can rate them. I used to just do it on a thumbnail, just 1 to 10, and do it blind because you have no real chance to choose a jury, and then never accept a jury. So the government or the court will often strike all the jurors for you and leave you with their choice. Now, it's never happened that we've lost a case where that's occurred on, so we've never got a chance to appeal it. But if the judge selected the jury for you and the prosecutor selected the jury for him, where does that leave you? So these are how you set up appealable issues, by the way. On the other hand, when I'm faced with a jury situation, I would insist that half of the jurors know me and the other half know my opponent. Now, it works well as opposed to disqualifying anybody on the jury that knows any of the parties. Because if the jury is to be impartial, it cannot have impartiality if it's ignorant. So charging somebody without having a driver's license is going to get him convicted automatically if anybody on the jury or nobody on the jury is aware of the issues. So you can't be compelled to have a marriage license unless you're planning on getting a divorce. That's the only incidence that I can think of that you have to have a marriage license. On the other hand, the only reason you have to have a driver's license is if you're engaged in a regulable activity for which the license is required. So it's not hard to understand. What's hard to understand is how do you get a jury to see this? So we usually put in documentation indicating that we want to pay the jury an equal amount that the prosecution is paying them. which is in most countries called embracery. On the other hand, is discrimination also. In most areas where I'm at, the first thing they're going to hang you with is a licensed lawyer to represent you or make appearances for you, which is very detrimental to the free exercise clause. So the free exercise of assistance and the exercise of counsel is differentiated by non-appearance or non-representation. If they're going to pay somebody to represent you and the payment comes from, quote-unquote, the government, it doesn't matter which branch it's connected with, because in our area the public defender's office is separate for for funding purposes from the prosecution or anybody else. But nonetheless, it's still government monies. And if the money's from the same source, that means it's the same master. And if it's the same master, no matter how they try to segregate it, you're being hung. So the jury's being paid by these people, the prosecutor's being paid by these people, the judge is being paid by these people, and now your defense is being paid for by these people. I submit that's not grounds for a fair trial. So now you're back to trying to require that you be afforded the opportunity to pay them an equal amount to provide for the jury, and or bribe them in any other way, which is really what they're doing. It's highly unlikely that somebody who is never going to realize a profit from you and is always going to realize a profit from them is going to fine for you. It just wouldn't make sense. I mean, any businessman could relate to that. But putting them on your jury that know you would require that half of them know the prosecution. If that happens to be the state of Texas, you got a real problem. Okay? Although most of them say they don't know the prosecutor or any of his minions, they all admit that they're citizens of the state of Texas, which puts them in an adversarial position to you, unless, of course, they're impartial. Can't be two things. They can't be impartial and say that they don't know you and they don't know the prosecutor, and yet they're all members of the state which is prosecuting you. I'd say that's a loaded dice. But in any event, jury selection chart allows you to write all these things down, and these are tear-out sheets, so you just tear them out and reproduce them, and then you're on to your next trial. Also, if you'll take the time to fill this thing out, it's basically 300 pages. If you would fill it out, you would be better informed about the trial, what has to be proved, who has to prove it, what's the method of proving it, what's the testimony expected to be, what are the rebuttal expected to be, than anybody else in the courtroom. In fact, it works so well that I'm surprised lawyers don't use it more. I mean, it's after all made for them. We have a couple other little tools that I use, and I tell everybody that's in the movement to get one of these, which is just a miniature tape recorder, and it'll drive people in the courtroom nuts, because in our state they have a monopoly on who makes a record. Now, I've had several occasions where this got in the way and provided so much distraction that the jury actually found for us because they were so vehemently opposed to the abuse that this thing brought out. For instance, we had a judge who asked me to turn one of these off. So he asked me plain, would you turn it off? And I told him plain, no, I wouldn't. Which now incurred the wrath, and he gets the bailiff ordered over there, and the jury's sitting there watching this. And so I protest, you asked me if I'd turn it off. I gave you an honest answer. Why is it that you're trying to get me, punished? So in any event, the jury was hearing all of this. The bailiff took it and in his haste dropped it. And little parts fell all over the place, which now brought a little bit of empathy up, although it was kind of a rigged deal. It was junk anyhow. But he couldn't help putting it apart. And the next thing that I usually bring with, which is very distracting to him, is this. This is a miniature a copier. So this thing, you take the cover off of it, and you put this on any document you want and pull it, and it'll make a copy instantly. So this is the scourge of the lawyers. In other words, they don't like this. This thing showing up means that you can get a copy within a heartbeat and put it back together and be gone. So they know what it is, and they're loath to let you near. So if you got this in the courtroom, they want to know what it is. Now, I had one judge almost dismantle it because he thought it contained explosives. Well, I admitted it did. They said the battery in it would possibly explode. Can I help you, sir?
Where can you get one of them?
This is out of Radio Shack. I don't know if they make them anymore. But this one says Radio Shack, portable copier, But it works so well, and it's caused so much consternation that I carry it with just for giggles. The other thing you need if you're doing any legal work, as I pointed out, was a copy of 28 U.S.C. and then a pen and a notebook. Have you ever noticed that people that walk into a courtroom with a pen and pencil make judges, lawyers, and even witnesses nervous? especially if they happen to be quietly sitting in a corner intently observing. Now, invariably, this disturbs enough people in there that they'll send a bailiff over to ask what you're doing. And of course, usually your response should be, well, what's your name? You know, because what I'm doing is observing what you're doing. Right? And if I had your name, I'd better be able to make a record of that. I have been asked to leave a courtroom. In fact, this is a federal district court in which I had a pencil and a paper, and they took them away from me for making notes in the courtroom. The judges, and this was this guy, the judge, Devitt, who wrote the federal rules of jury instructions. So the federal jury instructions are a product of Judge Devitt. And this guy was so paranoid of us that he literally confiscated all pens and papers. He wouldn't allow anything in the courtroom. Allegedly because it interfered with the smooth process of the court. You know, I'd say that's the mark of corruption. But nonetheless, they banned me from his courtroom too. Depending on your position, and if you're being accused or if you're prosecuting, and you have to be very careful that you don't mix these two. When you're using their system, you're subject to their rules 100%. Now, that doesn't mean that you can't make mistakes. I think Michael showed you that if you're pro se or in pro per or whatever you want to call it, that you're not subject to the same degree of the rules as they are, and there's some court cases to hold that up. Although I don't necessarily argue against that, I usually make my own path. So it doesn't mean that what you're doing is wrong if you're doing standard 42 USC. But I prefer to win under any condition. So I usually set up the issue whereby they're going to deny me some right to which I'm going to object, so that whatever happens, even if I do a poor case, I can always appeal it. So one of the issues that I'm most tolerant with is counsel. And because counsel comes under the 6th Amendment to the U.S. Constitution, and in most states, I think you have a dandy state constitution here, and it provides you can appear in person or by yourself. How is that stated? Oh, but before I do that, have you ever read Article 2 of your state constitution, which provides for the separation of powers? And just as an aside, it says, the powers of government of the state of Texas shall be divided into 3 distinct departments, each of which shall be confided to a separate body of magistrate, to wit, those which are legislative to one, those which are executive to another, and those which are judicial to another. And no person or collection of persons being of one of these departments shall exercise any power properly attached to either of the others, except in the instances expressly stated herein. Expressly stated herein means in the Constitution, not in the statutes. Now, if that's true, then as far as I know, no police officer carries judicial functions, which means that he cannot issue process, particularly summonses.
For citation.
Well, citation is a convoluted term used to identify a complaint summons combination, which has been authorized by the legislature, which is forbidden in Section 29, which says that to guard against transgressions of the high powers herein delegated, we declare that everything in this Bill of Rights is accepted out of the general powers of government and shall forever remain inviolate, and all laws contrary thereto or to the following provisions shall be void. So any provision following it also. And that includes separation of powers. So they could not lawfully make a law that would allow a police officer to issue process. Did that answer your question? It's really, in my state, we've skinned them on this several times. Yes, sir?
I was wondering, I understand that in federal court you can't take a tape recorder in. How do you get around that?
Well, in federal court you're not supposed to. You can ask permission to. I carry it because it's just like I carry my pencil. You know, it's just part of me. And but you can't even bring it in a federal courthouse, in theory. I just choose to do it. Now, normally what I carry is an operative one, because I want them to challenge me on it. So far they haven't. See, I'm always willing to be the guy that's almost wrong. But if it's inoperative and I'm carrying it for repair purposes, they can't hardly say that I'm trying to use it, right? So you can remove a battery or just take a wire off. You can do anything you want. But, you know, I'm aware that the sign is coming to the federal building. And, of course, they also say that if you come in here, you subject yourself to search, which is the reason I don't usually go in. In fact, I'm banned officially from several of them. Well, because the right to be secure in a person's house's papers and effects shall not be infringed. This federal building, in most cases, is a rental facility. So it's not, if you will, U.S. government, even though it's controlled by, but it has to be sold, and now under U.S. government power before that would be lawfully effective. So, you know, they just don't want me in there. I've had the privilege of being escorted rather violently out of federal buildings. I was cornered in an elevator by 3 of these crazy agents, and one of them was female, and they had this small elevator. 2 of them drew their guns, and the woman stood behind me with a threat to put a chokehold on me if I so much as breathed. So they escorted me out the door. This is a glass-fronted building, so I went peacefully and found a friend of mine sitting outside the door, and he asked me what happened, and I said, well, I'm afraid to tell you because it might be top secret. And so I said, but you can ask those guys, you know, they'll tell you. And so they said that if I came back in the building to him, that they were going to arrest me for trespass. Now, how is it that a federal official, guard, if you will, can make law? See, before you can be arrested for trespass, you must be lawfully unable or lawfully notified that you can't be there. He's incapable of giving lawful notice. So I went back in. And they brought their so-called senior guy out there, and they were going to do this arrest thing. And I said, well, there's 2 conditions under which you can arrest me. One is if I did something unlawful, and the other one is if I'm a threat to the security of the building, which would be unlawful. And which one of those is? He said, well, you're guilty of trespassing. I said, well, I could confess to that if I was willing to lie, but I'm not willing to lie. Say, if I were trespassing, then I would have somebody of competent stature able to tell me and to show me that I wasn't supposed to be here. In other words, you had to be communicated this. So he goes and gets his 3 flunky agents again, and he asked him in the presence of, we got newspapers around, in the presence of all these people, whether or not I was banned from the building. And he said, yes, we banned him. So then he said, what was your authority for banning him? Well, because we told him we didn't want him in here. He wouldn't submit to a search to go in a courtroom. And the newspaper's listening. And so one of them say, well, is that the new law that everybody has to submit to a search before they can go in a courtroom? And of course now they're not asking anymore, not answering anymore, and they disappear behind their little doors. I had the privilege of being drugged behind their doors and interviewed for potential terrorist inclinations, because they thought if I wouldn't go through the search thing, I must be doing something evil. And all I said was that if I go through this, that I would be subjecting myself to an unlawful search. And he said, well, why would it be unlawful? Everybody else does it. You know, the logic was overpowering. So when I declined to, they hustle you behind these doors, and they put you in these cuffs, which is an unlawful arrest, and then they put you in this little detention thing with a glass thing on it so they can talk to you. So you just got room to stand behind this door, and they talk to you. And of course, I'm fairly deep. At my age, I can afford that. And so they said a lot of things to which I wasn't responding. And then they would open the door and says, well, can't you hear us? I say, oh, excuse me? And then they'd try out the mic again. And of course, it worked fine. I said, it must be the switch when you close the door. You're going to have to put somebody in here to translate. So they eventually gave up and threw me out of there, too. But if you get into the way the Constitution is written, and all of the aforesaid was to be strictly construed, then they could not lawfully question me. Not in Texas, not in Minnesota, not in any state, without violating the right of the people to be secure in their persons, houses, papers, and effect. So my question, and in fact, this is what I suggest people do, is memorize your Article 1, because then you can ask every question with that as the foundation. You know, does not Article 1, Section 29 provide that everything written previous to Article 20 or Section 29 is exempted out of the powers of government? Yes, it is. Well, then how is it that my right to trial by jury is infringed by you? You say that a petty misdemeanor can't have a right to trial by jury. I read that it says the right of trial by jury shall remain inviolate. I thought inviolate meant without ability to color it. And then it says the legislature shall pass such laws as may be needed to regulate the same and maintain its purity and efficiency, provided that the legislature may provide for the temporary confinement. Say, now here's an amendment that doesn't match the first one. You can't have a temporary confinement without trial by jury. I don't care if it's even in the Constitution, because that's not what the original Constitution said. And the original Constitution is inviolate. Okay? Otherwise, your forefathers' words meant nothing. But anyhow, I mean, that's my method of doing it. In fact, all of my pleadings are devoid, in particular when I'm defending, are devoid of any case law. And they only use the constitutional provisions. So if you're being charged with speeding, then you're asking for the injured party. In effect, you're saying that you have a right to summons witnesses in your defense and that you summons the state of Texas. They're the ones that could identify the extent of the injury. But the police officer is basically a hearsay witness unless he's the injured party. He can testify about it, but he can't testify to it. So nonetheless, We have a gentleman in Kansas who's a dear friend of mine who has successfully prosecuted everybody who ever stopped him. Right? So if you start doing it, then pretty soon it's not worth stopping you. In any event, if all courts shall be open and every person for an injury done to him in land, goods, person, or reputation shall have a remedy by due course of law, means that in this state judges are suable, because that's what it says. Every person. So obviously there's no capacity to overwrite this. So I would say that these people would have a real long stretch. Now I'm not saying you'd be successful, but I'll bet you'd hit the Supreme Court. And this is the basis for your suit. In other words, this individual injured me, not in his capacity as judge, but using that as a shield. So John Smith did injure me, and I want the remedy given here. Now, because there's nothing here for a remedy, you invent one. Now, you're not restricted, by the way. Being resourceful is what changed all this law in the first place, because all of the amendments come about because somebody found a way around it, and so they amend it or they write a new statute. So you've got the same thing here on the bills of attainder. No bill of attainder, ex post facto law, retroactive law, or any law impairing the obligation of contract shall be made. So now your business doings, given that law, should change. You should not be operating as organizations or associations for profit. You should be doing what the law says, not affording the state an opportunity to impair the obligation of contracts. So everything you do needs to be done by contract, and not by association or groups. So if it's done by contract, all of a sudden the state has no method of inquiry into your business. The law says it can't be done. Now, that's your defense. All you're saying is that the activity of the state impairs the obligation of the contract. As an instance, let's say that I have you grow food for me on your farm, and I want the food delivered to me as the condition of the contract. Now, your delivering food to me does not affect the use of the public highway. Whereas everybody else usually carries their food in their belly, at least until they get to the bathroom. You're just carrying my food in the back of the truck before it gets to my belly. So it's incidental, if you will. The use of the highway is incidental. It is not a direct use. Now, if you're stopped, then you can use this as a defense, that you're impairing the obligation of contracts. I'm lawfully able to make a living in this state. I asked the state for no privilege. I made an agreement to provide food or sustenance for an individual in exchange, and I've done so. Now, for you to cause me to get a license to affect that contract impairs the obligation, or any variation thereof. You almost have to be as resourceful as they are devious. Every time they write a law, you figure out a way around it. Yes, sir.
I was just going to ask about this, what you're saying right now. I filed a DBA. I did not incorporate myself. I just went down and filed a DBA when I started my business, and I work for myself. Actually, I work for other people. So all my stuff is done by contract.
Sure.
But does the DBA hinder me in my obligations of contract?
Well, to the extent that the state can regulate what you're doing. So if you're doing business as First Bank, I'd say it's what you're doing that brings you under the state.
Okay. I do computer animations. I mean, it's not a regulated industry.
Okay, so there's no reason to have the DBA.
The reason I have the DBA is to cash checks.
Yeah.
Now, I put the DBA in my name. I am Kevin Dorita doing business as Kevin Dorita.
Well, the easiest way is if you, instead of taking checks, require cash. If they don't want to give cash, for instance, this seminar would cost $300 if you pay by check. It's $150 if you pay by cash.
Well, yeah, but I do $20,000, $30,000, $40,000 projects.
Yeah, that's all right.
They're not going to. Nobody pays me in cash.
Well, I understand what you're saying, but so you need a way to process it. As long as it doesn't involve you in the state, I shouldn't see any difficulty with it. But you could do the same thing by, what would you say, suggesting that you are operating as a contract, as opposed to operating by contract. Now, it's a little vague, but consider if I and my business partner, and we live in Taiwan, decided we wanted to do computer stuff here, but we don't want to come here because we don't like this, what would you say, socialist nightmare. So in any event, what do we got left for time? Okay. So we don't want to get involved in the socialist nightmare. You come over there and we say we want to invest. And so what we want you to do is operate our investment in the States. Could you do that? Now, you would be operating, if you will, in the contract. So you could do nothing that we didn't want done, right? And
Right.
yet you wouldn't be a DBA, would you?
Not
So
necessarily.
you'd be representing the contract. And that's
Okay.
all it would be. So you don't have to file that. But it's just another way to look at things. It's one of the best ways. It beats a trust.
I'm led to believe that DBA is doing business as.
That's correct. DBA is doing business as. Of course, you could call it a lot of other things too.
Dwayne?
Yeah.
Yeah, in your scenario, quickly, with a driver's license, would that scenario still hold?
Well, the driver's license, if you're applying for one, you should apply for one if you need it. So there's nothing wrong with you operating for profit and gain on the highway if that's what you choose, but you're limited by the license.
Well, I know, but you were carrying food to the farmer.
No, it's
and-
not a licensable or regulatable activity. See, where I come from, it's accepted fact that no license can be required to sell or peddle the produce of the farm or garden. That's what the law says.
So in this scenario, one has nothing to do with the other. In other words, you're carrying food to the farmer, and the officer says, you don't have a license. And
Right.
you say, well,
I'd say
No,
your
I'm
powers
cur-
of observation are not diminished by your age. Yeah. But nonetheless, no, I use a commercial license on a regular basis. And what I use it for is to establish that I'm not engaged in a regulatable activity. And the scenario goes thusly. Were I to misrepresent to the state that coming to visit you people was a licensable activity, I would be violating their obligation not to regulate the right of the people to peaceably assemble. Because if peaceable assembly requires that I get their permission to do so, it's obviously not a right. It's now a privilege. So conversely, the use of the public way for profit and gain is regulated, provided I've set up the business on the highway, or the use of the highway is the business, which a corporation would do. A fiction is immune from what we say prosecution, except to the extent of its asset value. So it's licensed. So if it injures you on the highway, it must be able to pay for the cost or the injury. You, on the other hand, are I and my business partner, and we live in Taiwan, decided we wanted to do computer stuff here, but we don't want to come here because we don't like this, you know, what would you say, socialist nightmare. So in any event, what do we got left for time? Okay. So we don't want to get involved in the socialist nightmare. You come over there and we say we want to invest. And so what we want you to do is operate our investment in the States. Could you do that? Now, you would be operating, if you will, in the contract. So you could do nothing that we didn't want done, right? And
Right.
yet you wouldn't be a DBA, would you?
Not
So
necessarily.
you'd be representing the contract. And
Okay.
that's all it would be. So you don't have to file that. But it's just another way to look at things.
Okay.
It's one of the best ways. It beats a trust.
I'm led to believe that DBA is doing business as.
That's correct. DBA is doing business as. Of course, you could call it a lot of other things too.
Dwayne?
Yeah.
Yeah, in your scenario, quickly, with a driver's license, would that scenario still hold?
Well, the driver's license, if you're applying for one, you should apply for one if you need it. So there's nothing wrong with you operating for profit and gain on the highway if that's what you choose, but you're limited by the license.
Well, I know, but you were carrying food to the farmer.
No, it's not a licensable or regulatable activity. See, where I come from, it's accepted fact that no license can be required to sell or peddle the produce of the farm or garden. That's what the law says.
So in this scenario, one has nothing to do with the other. In other words, you're carrying food to the farmer, and the officer says, you don't have a license. And
Right.
you say, well,
I'd say
No,
your
I'm
powers of observation are not diminished by your age. Yeah. But nonetheless, no, I use a commercial license on a regular basis. And what I use it for is to establish that I'm not engaged in a regulatable activity. And the scenario goes thusly. Were I to misrepresent to the state that coming to visit you people was a licensable activity, I would be violating their obligation not to regulate the right of the people to peaceably assemble. Because if peaceable assembly requires that I get their permission to do so, it's obviously not a right. It's now a privilege. So conversely, the use of the public way for profit and gain is regulated, provided I've set up the business on the highway, or the use of the highway is the business, which a corporation would do. A fiction is immune from what we say prosecution, except to the extent of its asset value. So it's licensed. So if it injures you on the highway, it must be able to pay for the cost or the injury. You, on the other hand, are subject to the common law right, which is to make me whole for every injury to my person, property, or character. There's no correlation between the two. If I have to have a license to go down to get a license, I'm never going to get there. It doesn't make sense. It's an absurdity. So what you're doing then is admitting that you need a license. So you're hiring public transportation, which is licensed, to take you down to obtain a license. You know, it's asininity. Yet 90% of the population believes you have to have a license. I submit that if I had a marriage license, I'm married to all the women in here. No, it's very singularly relegated to that particular application. So when I apply for a license, it's to do that which, by law, would be illegal, unlawful, a tort, or a trespass. Okay? And coming to see you guys isn't illegal, a tort, or a trespass. Nor could it constitute it if I did it at 90 miles an hour. It just I got here faster. Some of these traffic issues, we don't have time to go from now. We've got about 2 minutes left. When we get after the break, we'll hit some of them. Some of the traffic issues are so entertaining, and yet they're very informative when you try to put this together. If you were to admit to a police officer that, or if I were to admit to a police officer that I required a license to get down here, it could be construed to be a violation of federal law, which is giving false information regarding interstate commerce. I'm not in interstate commerce. Yet crossing straight lines or state lines would involve interstate commerce according to their reasoning. So the gentleman from Hawaii, Zane, who's been charged with what we say falsifying Hawaiian material or falsifying government documents, Texas has no capacity to enforce Minnesota law or Hawaiian law. So for them to charge it is false. In fact, it's criminal. And then for them to say that he falsified their paperwork is just patently wrong. There's nothing in Hawaiian law that I'm aware of that says you can't change anything on the form to correct it. You know, if the form is misprinted and it says asshole size, and you put it, oh, I see, hat size is what it meant. So you just, you don't have to put this down. But that's what they're telling you, that it would be a criminal act to do so. But nonetheless, a lot of this is just plain good entertainment when you get up and do it. We have applications in Minnesota that are separate, so a commercial application is different. And some of the questions are unanswerable. You know, they have one question on the test that says that if you're going down the highway, you know, this presumes you're driving a truck, and you're expected to stop in a reasonable distance. Is that distance the length of a football field, twice the length of a football field, or the length of a soccer field? And I said, I don't play football. How the hell would I know? I don't play soccer either. So these questions are just out of the blue. And these guys sit down and dream up this crap. And you're supposed to respond to. Now, they did change that question because I made so much of a stink out of it. But they think that everybody's involved in their activities. In any event, what do we got left on that, Peter? 2? Oh, 3. So, well, we have time for a quick story. I had a gentleman that followed me from the southern part of the state in a truck. And as we were coming up across the line, and I have a truck, and I go by this weigh station, and which is a no-no. You can't go by a weigh station if you're driving a truck. Now, this truck happened to be my transportation. It was just a good bargain, and I couldn't resist it, and I like big wheels. So I'm banging up down the highway with this thing, and the guy behind me gets on the radio and says, hey, you missed the weigh scale. I said, no, I didn't miss it. I'm not engaged in that activity. I'm not going to stop. So, and this is right near the Minnesota border. So pretty soon here's this Iowa patrolman. He comes up there, and I park literally right on the line. So the truck's half in and half out. And he comes up to my truck and he said, I need to see some identification. And I do my standard dog and pony show and ask him if, you know, it would be advisable for me to remain silent, or was he going to arrest me? And he says, well, I'm going to arrest you if you don't give me some identification. So just hold out your hands. Now, what's he arresting you for? There's no law, and in particular in Minnesota, they actually enforce this, the right to remain silent. So, of course, he's in Iowa yet, and I'm in Minnesota. But he's standing there, and he's got this thrilled look on his face, because he's going to have a truck to confiscate, and he's going to have somebody to incarcerate, and I'm just living it up, you know, because I got a driver's license in my pocket. I just can't show you unless you let me mislead you. So I'll tell you any lie you want to hear. Okay? And he says, you better not lie to me. I said, well, I said, good evening, officer. That's a lie. You know, it's neither good, and neither is it evening. Of course, it was, you know, afternoon, but it's neither good nor was it evening. And I doubt you're an officer. Right? Officers are, if you will, by appointment. So, you're a paid employee. You punch a time clock. And he said, well, that may be true, but I'm still a police officer. I said, well, police is the word for policy. Its root is policy. So you're a policy officer at best. He said, I ain't putting up with this blankety blank stuff. And so now my friend's coming up behind, and he parks behind the policeman, and he gets nervous, the policeman does. Because, you know, two big trucks, you do, one has to back up, the other has to go forward. But nonetheless, and I'm making hand signs, you know, just for giggles. And this policeman is extremely nervous, so he goes back to his car, and you hear him calling for backup. And I said, well, tell him to park at least, you know, 15 feet behind his truck, because we have another truck coming, and we want to be able to, you know, which is not true. But they don't care. Anyhow, pretty soon you've got the third police car lined up there, and I'm still making my hand signs, you know, doing this thing. And they finally get the idea that you're just jerking them around. Now, the question was, why didn't you stop at the scale? Okay. And, of course, I said the scale wasn't open. And he said, everybody saw it was open. I said, now you know why they don't let me drive a truck. But he finally talked me into giving a driver's license so that he could look at it, and confirmed his worst suspicions that, you know, this guy was trying to engage him in something unlawful. And I even told him I have a piece of plastic for morons, idiots, half-wits, and assholes. But otherwise I wouldn't show it to anybody normal. When the lieutenant came up for his support, he decided that it was worth seeing, even if he had to take that kind of abuse. So now when you get to it, I mean, what are you looking at? I'm not engaged in a regulatable activity. This truck has nothing on it. It's got my sleeping bag at the back end, but that's all it has, and it's my private conveyance. It's not registered for highway use. So now, any farmer in Minnesota would tell you that you don't have to register trucks in Minnesota, and yet almost all of them do, right? Because they don't want to be stopped. We proved it. I parked my trucks unregistered on the highway because I own a farm, and dared them to give me a ticket. They just don't do it. Now, when you're least expecting it, they do it. Right? They tow you. So you have to, you know, count the cost. Are we out of here now?
Keep going.
Okay. But in any event, when we get into the courtroom scene again, in fact, we were going to set up a jury trial just so you guys get a chance to see how it's played. You only got one on that? Is that what you're saying?
No, 1 minute? 1 minute? Okay, yeah, then we're going to take a break.
We're going to take a break.
We are, he said as he stumbled uncontrollably for the equipment, we are going to take a break. Mr. Rogers is available on a fee basis for you consulting on your legal problem. We will also remind you that
to him, and you say, if you give me immunity, I can't give it to you unless you give me immunity. Where does that relate back to the Constitution?
Oh, well, immunity in that sense is the right not to be compelled to give evidence which would be used against you in a criminal case. The question basically is based on whether or not if you require or if you deny a police officer access to a driver's license in your possession. And of course, my theory is that if you're not engaged in the activity for which a license is required, it would affect a criminal offense on your part. In effect, you're misrepresenting what you're doing as opposed to misrepresenting the license. In constitutional parlance, it's unlawful for you to, what we say, deceive any official of government in the performance of their duties. So I just always relate it back as if I'm stopped, is this a criminal investigation that you're stopping me for? If the answer is no, I'll see you later. If the answer is yes, would you punish me if I exercise my right to remain silent? Would you compel me in a criminal case to give evidence which you intend on using against me in violation of your oath of office? And so it comes down rather persuasive on your side for a change. I have a question, sir.
In Texas, the statutes say that you can be required to identify yourself if you're under arrest. You're clearly under arrest when they stop you on the streets.
Well, actually, if that's true, then when they apprise you of your right to remain silent, they just made a mockery out of the case. And of course, the case comes, Miranda versus Arizona says that where rights secured by the Constitution are in question, there shall be no rulemaking or legislation which would abrogate them. Texas constitutional law, Article 1, Section 29, says that these rights hereby secured are of such high powers, we declare that everything in the Bill of Rights is accepted out of the general powers of government. So the right to remain silent is therewith enforced. So your position is that I would gladly honor you if it didn't cause you to violate your oath of office, officer.
Well, the last time I was stopped, I asked him, am I under arrest? The first thing. He said, oh, you're not going to jail or anything. But he wouldn't tell me whether I was under arrest. Yet
well, you can force the
case
issue.
law says that I was under arrest because I was deprived of freedom to move.
But the next question is, if I'm not under arrest, am I free to go? If I'm free to go, then we don't have a problem. If I'm not free to go, is the next question you ask me going to be used to further your inquiry? Because that's really all you're doing. What's fun is when you get them on the witness stand, because all of this rhetoric doesn't do you any good if you don't know how to use it. So when you get into the courtroom and you decline to offer a driver's license to the police officer, and in this state he would charge you with failure to identify yourself, although I think they can't charge you with failure to identify yourself unless you're already arrested on a valid charge.
Or detained.
Or detained. Yeah, that's even more interesting. Brown versus Texas would overturn that. So because Brown versus Texas says explicitly that a policeman can ask you any question he wants. You are not required to respond in any manner. So what would you do with a deaf mute? This guy'd be in jail forever. But nonetheless, when you put him on the witness stand, things are even more interesting, because now you can ask the officer the questions that he's been longing to hear from you. In other words, aside from the probable cause things, I don't know how many people go through probable cause hearings or omnibus hearings or anything else in criminal cases, and because basically today we're working with civil, not criminal, I won't get too far into it. But if you're at the probable cause hearing, the first thing the police officer has to state is why he stopped you, which effectively should state the facts relating to the events. So he's going to say, I was monitoring traffic, and I was on duty, and I was on watch, and as I was monitoring traffic, I saw this car come flashing by me, and that constituted probable cause. Now, he can also say that he's been a policeman for 10 years, and he's able to observe the relative speed of vehicles, etc. But what he can't say is whether or not the vehicle was engaged in an activity for which it was made itself subject to the speed laws. Now, there are common laws with respect to speed, in that you can't intentionally injure another. And if you do cause even fright in another, that you have, or you owe them at least that measure of respect so that you wouldn't cause them to be frightened. But if you're going on the highway at 60 as opposed to 55, I doubt if that could be fairly pleaded. Conversely, if you have a truck on your tail that's doing 85 and you're stupid enough to stay at 55, you ought to get your tail kicked. Yeah, Kessler?
You sound pretty knowledgeable on this. Maybe you can answer this question that nobody's been able to answer yet.
I know I'm being set up now.
The so-called traffic laws, such as speeding, etc., are under Vernon civil statutes.
Right.
Civil, and yet policemen can arrest you. Basically, the citation is an arrest, which is criminal.
Sure.
How do you get from civil jurisdiction into criminal?
You don't lawfully, but I'll tell you how they're doing it. The rationale behind it is that the motor vehicle codes in all states are civil. They have criminal penalties because they involve contracts. So there's an inference, if you will, in the statute that anybody that's upon the highway is subject to the laws of the state respecting the use of that highway, which is a fair presumption unless it's rebutted. So if you look it up in Black's Law Dictionary under due process, that no presumption of fact can be assumed against you because it would be violative of due process of law. And there's a case cite for it, but I don't know what it is. In any event, what they've done is cross the boundary to put everybody in the military. So in effect, if I came to anybody in this room, I could establish for purposes of the Admiralty that all of you are AWOL from Fort Benning, Georgia. And because none of you have any papers to disprove that claim, you would have to stand before the magistrate. Okay, now it's a plea and bar. So if you want to use the old terms. But nonetheless, you would be foolish to plead at all. You would let me bear the burden. So I go in there as the Admiral's servant, and I show that this individual failed to display leave papers of any nature. And sure enough, the Admiral would say, "Is that true, soldier?" And you'd say, "Excuse me, soldier, did you say?" I wasn't in the military. I've been in the military in the last 40 years. Oh, MP, now you got a problem. Except these judges are as blind as they are illiterate. And it doesn't help you to go in there and say, "I don't understand," because they don't care if you don't understand. Your best defense is a good offense, which is why you set all this up. And then if you were doing what I was doing, you could explain that it would be unlawful for you to give evidence that you were in the military if you were not. It would be unlawful for you to have in your possession leave papers or authenticated leave papers from the military if you were not in the military. Equally, it would be unlawful for you to misrepresent the capacity in which you were acting. If you're on your way to get a license, it would be inappropriate for you to say that you had to have a license to do so. But that's what they're implying. So while they are acting under the criminal side of the Admiralty law, they're not telling you that, which is one of the things. There was an old gentleman that used to go around the country, Howard Friedman, that had this down to a science. Now, I wouldn't do what he does, obviously, because Howard knows what he knows and I know what I know. But in any event, the same capacity to ask questions is still there. You can always ask them under what rules you're being tried. And they'll say the the state code of criminal procedure. So now you can say, well, does this govern common law? Does this govern Admiralty law? Or does this govern, if you will, criminal, the side of Admiralty law? And he's going to be puzzled, which doesn't bother you at all because you don't really care what he's saying. What you're trying to point out is that you haven't been notified. Right? And there are no published rules for traffic courts. That's where they got you. And that the traffic code is found on the civil side, and that you're unable to equate the two. Although we've been able to do this on discovery. If you're charged with violation of not having a driver's license, you immediately contact the Secretary of Transportation and ask for evidence that there's no driver's license to be found for you, and they'll comply. You don't have a driver's license. So you can now go in and prove beyond a shadow of a doubt that these people have no evidence whatsoever of a driver's license being accredited to you. And all you proved is that the officer could have done the same thing. If the state didn't issue a license, you couldn't very well show one. You couldn't very well claim one. And had you said you had a license, or were you trying to show you had a license, that you would in fact be violating state law. What they're trying to do is compel you to say that you were supposed to have a license. Okay? So if you used the discovery procedures, you could now go to every state. See? And then when you got into court, you could offer evidence that every state had admitted that you didn't have a driver's license, and that you weren't engaged in any regulatable activity that the state was aware of. Because the Secretary of State will tell you that. Okay? So all you set up was the conditions that, to the best of their knowledge, all of these state representatives had established that you weren't involved in a regulatable activity for which a license was obtainable. It's just cut and dry. Now, you always leave one out, of course, and when they got done saying, well, that conclusively establishes that you don't have a driver's license anywhere. And you say, no, no, no. There are 183 licensing jurisdictions in the world, and I haven't contacted any but these 48. Right? So to prove that you don't have a driver's license is their burden, and you can help them. You can demonstrate. I've put them on the stand repeatedly. Same question. Did you check the jurisdiction that's immediately north of you, called Canada? And of course they don't. They don't have any communications with those. Are you positive that I am not licensed in Canada? Well, no, I'm not. Have you checked any of the provinces of Canada? Can you establish beyond a shadow of a reasonable doubt that I'm not licensed in any of the provinces of Canada? Now we're going to move to Europe, by the way. And so now have you been to Sweden with these inquiries? Are you absolute? Because they're going to say, well, what? They say the first condition they have is to prove your residency. And all they can do is say that you live at a certain address, and of course you can deny that. Remember, it's just a presumption thing. So you can establish unequivocally that you don't live at that address anymore, that you're alive and well in this courtroom at this minute and this hour. And these are all witnesses. As facetious as it sounds, that's what the meaning of the word is, unless you're involved in fictions, in which case you become resident. And the residence is a capacity whereby you can receive state privileges, i.e. license. And that'll put you right in that jurisdiction in a heartbeat. But I've had a real good time in court because I've, over the years, accumulated enough background to know how witnesses are set up. And I love expert witnesses. Expert witnesses are the most fun to toy with. We have a couple of knowledgeable people in here who know what I'm talking about, because every expert has an ego problem. He's being paid. So the first thing that you attack is it likely that we could change your opinion if we paid you more money? Now, the question is rhetorical, but nonetheless, the jury's made quite aware of it. You know, that this is a paid whore, I mean a paid informant. And as you expostulate on that, they become, what would you say, titillated, because your next question is usually in the same line. Did you rehearse what you were going to say? Now, if he says no, then how did you become expert in what you're doing? Okay. If you didn't rehearse, if you didn't practice. So all of these things are scheduled, and usually if you use this trial book, you'll write all this down. You know, how to handle the particular experts. We have an expert that always shows up from the Department of Transportation that won't show up if I'm on the trial. Because we've ridiculed him so bad. You know, he's a highway engineer that knows absolutely nothing, right? He's like a toad. He just sits on the highway waiting to get run over. So that's what we use him for. But he's an interesting character because he always testifies to the same thing. And invariably he'll testify that the speed law in Minnesota is not 55, because even though the statute or the sign says 55, it's 65. Because there was an emergency, a gasoline shortage emergency, however contrived. The legislature reduced the speed law until emergency was over. So all you have to do is find out availability of gasoline throughout the state. You can do this through AAA, and AAA can be your expert witness. And if there's no emergency, then the law is not effective. Right? And this guy will testify right out of the law book that the speed limit in Minnesota is 65, because that's what it says. And so now, how much trash are they going to have to eat? So they don't even show up anymore. Usually they do their best to, you know, admit defeat, walk away, and we start over again. Yes, ma'am. Oh, I'm that old. Thank you. Nonetheless, as you get more expertise in this, and I would suggest, and I heartily recommend you start a class of some sort that just practices in the courtroom. You can go visit courts. It's a good way to start. And then, like I said, we used to do, let's just write down the title for everybody that you wanted to have an actor for in the courtroom. And as the guy walks in, he draws it out of the hat. So you don't know if you're going to be the judge or a juror. You don't know if you're going to be an expert witness. You don't know if you're going to be what. So when you walk in, you're now in for a surprise, and you become rather versed in what you're doing. And it's very laid back, although some people are just as nervous in class as they are in the courtroom. I have yet to be in the courtroom, by the way, that I didn't have sweaty palms. Sometimes butterflies got out of formation in my guts, or things like that. But it's never failed. And yet that's when I'm at my best. If I'm nervous, I'm at least aware. If you're not nervous, you're cold and indifferent, which is the nature of most lawyers. They've been there too often. Excuse me, most judges, they've been there so often, they're immune. I happen to be of the opinion that a little bit of laughter in the courtroom is good. And I don't mind being the source of it either. So I usually laugh at myself. I tell them how stupid I am and how ignorant and how funny it feels to be up here trying to convince people who obviously know more than I do that they don't know what they know. And that's exactly the response you get. But anyhow, I've had a few judges admonish me for it. And most of them no longer are cynical about it. Some of them used to be facetious. But if you happen to be a judge and you admonish me facetiously, I'm going to humble myself, because I'm going to say, do you want me to prostrate myself before you right now? How can I again gain your pleasure, or whatever it takes? So they don't do that anymore. They just say, Mr. Rogers, we have been here before. We are not going to go through this anymore, because I've been known to grovel. And groveling is very amusing to somebody who's never been there before. In any event, as you get into this ritual of practicing in the courtroom, and I suggest that you get a copy of the state constitution and remember the first 29 sections, get a copy of the rules of courtroom procedure, And by all means, practice it. Among yourselves, send a deposition or notice of deposition, requests for admissions, requests for interrogatories. Learn how to write interrogatories. Learn how to avoid conclusionary allocations. You'd be amazed at how critical you are of each other, and nobody's going to influence you. No lawyer's going to shut you down. You can make pretend suits or you can get real ones. I was telling a guy that one of the best ways of removing yourself from the public view is to lose everything you have. So if you were foolish enough to cross horns with me and we got into a contest and I sued you and you agreed with me out of court that you didn't want to go to court with me and I took everything you had, you would have effectively lost everything you had. Right? It's totally lawful too, by the way. So there are a lot of things you can do that you haven't imagined yet, and you'll learn a lot about it if you practice courtroom procedure. Every lawyer wishes that he had a group like this to play with. Really, I don't know any lawyer who wouldn't. I have lawyers that call me up and pay me to sit down and trade barbs with them. You know, I'm probably the worst witness you could have. You know, first, you know, I don't do oaths very well, and when I do, it's very disruptive to the courtroom and the jury. So the last thing you want is somebody like me, if you happen to be the prosecuting attorney, or excuse me, the prosecuting attorney, I'm on your team, and I come in there and you're unprepared for a witness. So they use me to practice on witnesses, which is kind of a neat deal. Because if they ask me to raise my right hand, I'll volunteer my left foot and pass gas. One's as effective as the other as far as believing me. I usually intersperse that I'm a compulsive pathological liar, and I'm very good at it. How you're disposed, if you happen to be on the jury, you're going to wake up. Now, most of them come alive at this point, and because trials are boring to most people. But if you're faced with some witness like that, you're going to be awake. So now a lawyer who is intent on boning up on his courtroom skills finds me a challenge. You know, because that's good. And they're not upset by it. They know you're just a smart ass looking for an audience. No. But you get in that courtroom, they'll find out. I've had judges really try to grill me. Which, strangely enough, I mean, that's an adrenaline rush for me, because I'm thinking inside, I bet you can't. No, and so you got this arrogant attitude that starts showing through, and they're doing their best. I'll hold you in contempt if you don't answer this question. Oh God, please don't hold me in contempt. Which is Bear Rabbit saying, don't get me near the briar patch. I would know what to do. You see, because the next thing he's going to do is get answered with a question. So he says, would you state your name for the record? Are you going to hold me contempt if I ask that question or answer that question? Excuse me, if I answer that question. And he says, well, no, I told you I'd hold you in contempt. You didn't answer the question. Oh, I don't know the answer. I can't state my name for the record. I'm so intimidated I can't even think about it. So now you're going to throw... But you see what happens to it? And they are not always pleased with the results. Nonetheless, if you happen to get a witness on the stand that's that way, I can show you how to handling. You know, it's kind of neat. The more perverse you are, the more you know about being perverse, right? So you can usually undo what they can do also. So nonetheless, if somebody told me they're a compulsive pathological liar, I'd tell them to prove it. You know, we need some sort of proof, because if you're a liar, you're not to be believed. Right. So, of course, now... It is so destructive of common sense and reasoning that people can't imagine how you'd believe a compulsive pathological liar. Actually, that's the only reason to believe him, because he is. Now, if you have the opportunity to cross-examine somebody like that you know is a liar, I mean, I'd like to have this Mr. Furman out there in California. He would be choice, because he's got an ego. And all you'd have to do is, it's called leading, and at that point, any judge would let you have him as a hostile witness. So you can be leading, or you can't be suggestive, but usually leading is suggestive. So you can do a lot of those things. If you're familiar with the forms of objections, though, they couldn't do it. So, I mean, there's lawyers that are so good with objections that you can't ask questions of them. And, of course, there's lawyers that are so bad they don't know how to object. And personally, I like the kind that make a lot of objections, because then you have a chance, if you will, to think. And invariably, if you are the witness, the best responses you can give are still the same. And I've prepared a lot of people for juries and grand juries. Gee, if you're not honest with yourself, the first thing I try to do is get you to see that you don't know what you know. It's what you know that ain't so that's got all of you confused. So even the strange things like, where do you live, is best answered directly. Oh, I'm right here, I'm alive. And if they ask you, well, don't you live at 318 Marshall Street? You can say, well, sir, that would be misleading you. I'm alive here. right? Because they're really asking you is where do you have your business set up? Or they say home. Business and home are almost synonyms in legal contemplation. So most businesses have home offices. But because you're not caused to think of that, you're never given that opportunity. So I usually do it the other way around. I'm unable to answer the question based on the method of postulation. And you go, huh? Yeah, you see, if I said that I lived there, you'd say, well, this fool's a liar. He's obviously alive here. Or he's good at projecting. But nonetheless, I couldn't answer the question the way it's postulated. He said, well, perhaps you could tell us in your own words. Oh, yeah, I'd like to do that. But I forgot them, too. But you can do this almost nonstop. And in fact, we've done it in depositions to where the lawyers have just become enraged, and they'll attempt to bring sanctions against you. And I've had judges sit up shop at the deposition, so they just bring the deposition.
And Bob Filer saw me. And he was there when we did the commercial for Canine Corral in Huntington Station. Probably in the year 1987. Almost 15 years ago. And he's working for FedEx now. And he works part-time for another puppy factory. And this is why it makes it so hard for Acumen to find a home. Let us make a record of this. Charles Dolan just broke the law for 105th time. He refused to show me the shareholder. Whoops. Sorry about that. I gotta get some Velcro. Attaches to the dashboard. Charles Dolan just broke the law 105th time. Refused to show me the shareholder books, records, and minutes and ledger, which I, as a shareholder, have a statutory right to see. The time is 10 minutes before. Ellen Johnson was at the receptionist's desk, and she asked about Franklin. Oh. when we get to buy the things, you hold on to the dog so he doesn't bark in the window. Police station, new houses. This was all woods. 5:10 p.m. 4th of July Eve, Tuesday. Handed in 6 tapes, picked up 12. Saw the public access file, the phony public access file, and the phony least access file. It was all ready for me when I walked into the door. B gave us 4 glasses of water. Frank gave us 1. Ackerman had a good run. Now back to Lynbrook to get the articles forgotten. Folks, we had moved. You know, you saw the gangster movers. I had a movers from Brooklyn. $3,000. This is rougher than usual, and this is our new museum, and that's Acumen. So it was a nice day, folks. We had a good time. Tomorrow, Wednesday, is an in-day. Top priority is a chat with Glendora. Getting it ready for next Tuesday. And then 10 legal papers. 1 Alaska, 2 Buffalo, 3 Vermont. All bad judges. 4 Adam Moving. 5 Philadelphia Calabrese. Just explain to me how a case you never filed in Philadelphia ends up in Philadelphia. Now they've done that several times. The crazy mutts in the federal courts. Brown. You got to write Brown and congratulate him. I can't afford to call him. Omnibus for July. Suing more judges. Is terrific. Name this highway, 10 seconds. Northern State, west. Glen Cove. Name this highway, 10 seconds. I-95, Clearview, going toward the Fox Neck Bridge, where they have neurotic cops taking the toll. I-95 going north, New England, New Haven. Cliff dwellers. I don't see how they stand it. Cliff dwellers. Co-op City. Coming onto the hutch. July 10th, 6 p.m. Thursday, 2001. This is Friday the 13th, folks. We're going to the county courthouse. And we're going to picket one of the worst judges there. And there are quite a few bad judges there. And it's about 1:30 p.m. Sachs just notarized, and Carrie just served the complaint, City Court, City of Rye, against Godfrey S. Godfrey S. South and his brat son, Mark. And this morning I picketed south. I should have had this camera to show you how it's done. And that was at work at the hospital. I saw him at 8 o'clock, straight up. He was crossing the street, but I didn't want to call his name because he could have got killed by the traffic. I don't know whether he saw me or not. We did not have eye contact. So he's been ticketed there. I went to the Mount Vernon Police Department to get the police reports of the movers when they stole our goods, and the police went after them and brought back the moving truck. And the Mount Vernon Police, that was on June 28th. Mount Vernon Police has no record of it, or none that Doneen could find. And also, I wanted a copy of the police report for July 1st when Self called the police when he wouldn't give us back our security deposit and the interest. Maria's husband is on trial. The jury is deliberating, and they have been deliberating for 3 days. And that's somewhere up here. And what else? I did all the out mail. Yesterday, Thursday, the legal papers were up to date. I have a whole bunch of legal papers to read to you. Brown has sued the Second Circuit, and boy do they need it, and I am thrilled. I'm so thrilled I might ask him if I can be an amicus curiae. My picket sign says dump de Blasey. And I'm going back and forth in front of the courthouse on White Plains, city of White Plains property, not on the county of Westchester property, because I have a permit from the city of White Plains, which is really unconstitutional. This is what they call the low-rise building. That's where the county executive's office is. Anyhow, so I have annotated the first 10 pages of Brown. There's 25. It's a terrible, terrible case. I don't know, it's worth reading the whole thing to you to see how badly they are conniving, the district attorney and the U.S. attorney. And then the next great paper was the July Omnibus. Omnibus 4 is being filed in the United States District Court, District of Hawaii, and it's Glendora versus John M. Walker, Jr., the Chief Judge of the Second Circuit. No improvement over Ralph K. Winter. And other people, I'll have to read that to you. The Alaska court pooped out. They're no good. Singleton is no good. And the Buffalo court is no good. The Vermont court is just plain negligent. These are all federal courts. And Philadelphia thinks that they have Glendora versus Calabrese. Well, that was filed in the District Court, United States District Court of Arizona. Can you tell me what's wrong with these federal courts? Fire Meekum. What a mess these courts are. And they never get any better. This court is falling apart. Physically, just the way the justice system is falling apart. And Gulf Oil, they had to go to the expense of hiring a lawyer in Alaska and writing a defense. But the bad judge named Singleton in Alaska was no good anyway. So I didn't even read that, because it's a nullity. But I'll read the paper to you. There's a whole stack of them in the museum to read to you. Okay. So I guess that is picketing de Blasi. I guess we'll go up to the car now and go to White Plains Public Access and White Plains Post Office and the Center for Judicial Accountability. Must be about 2 p.m. Friday the 13th. Where de Blasi was promoted, and then after he cheated and missed court 31 mornings to take a course in the Connecticut School of Broadcasting, he was demoted back to there. This is the old post office and the New York State District Attorney, who's good for nothing, moved out of there. No, it's the Attorney General. Excuse me. The District Attorney's no good for anything. A dog in a lounge chair. That's pretty cute, isn't it? Huh? On a Saturday morning, July 14th, Bastille Day. Rocky dog, Acumen dog, and Trusty Rusty. Trusty Rusty. Yeah, Trusty Rusty. Acumen did such a good job on clearing up that cyst on Rusty's head. And how Rusty loves a bed. I washed all these blankets for him. This is Saturday. We've already done an hour and a half on Brown. It's done for the day. Brown sues the Second Circuit. They should be sued every day. It's pretty lucky the way the museum fits so nicely in here. It's much better. It's a big improvement. I think it's 20 columns. There's desk 1 where you write it, desk 2 where you print it, desk 3 where you collate it. And here's Trusty Rusty. Trusty Rusty. And that's Rocky's bed. And Rusty sleeps in the red chair. And so does Acumen. And the Boston rocker. And this is the TV monitor, the Cypress desk, and Franklin's World Series monitor that we paid $5 for. And this chest of drawers that Glendora's father, R.A. Folsom, made. Isn't that cute? This is lounging Franklin Buell, accompanied by a white dog, and there's a black dog slurping, and here's a chocolate dog. It's Saturday, July 14th, Bastille Day. Like. Hi folks. Glendora, Sir reply to Natoa Anderson, no meritorious defense, cross motion must be granted. This is to the United States District Court District of New Mexico. And this is the long list of defendants. The first group is DCTV, who doesn't know enough to cablecast a chat with Glendora. And the second group of defendants are the Dolan defendants, who burden public access producers with illegal rules. And the middle group of defendants is BCAT, Brooklyn Public Access TV. But the two defendants here answering are Natoa and Anderson. And so this is their reply. That's Acumen making all that noise. Their reply, they did not get permission from the judge to make a motion without my consent. So I should think that would disqualify it right away and give me summary judgment. Their caption is incorrect. What is inadequate is a decision of the judge, and they don't specify what is inadequate or why it's inadequate. And the court decided it had jurisdiction when the court sent the marshals. Judge Parker did that, James A. Parker in New Mexico. This got all wrinkled because I was carrying it in the bag to videotape for you last week, but I never got a chance to. It is to be treated as a cross motion. It is not clearly valid. This is nothing but rhetoric. They make all these allegations and then they don't substantiate them, so I say why. No defendants failed to defend. No issue of fact. I say I should have summary judgment. This is a very flimsy paper. NATOA is the National Association of Television Officers and Advisors. They don't give very good advice. In sum, defendants have no meritorious defense. This is not an answer. It is not a reply. And because they're so desperate, they start talking about the other courts who've taken away my rights because they're so afraid of my papers. They get scared stiff when they see a Glendora paper, and they either return it or dismiss it right away because they know, come on, quiet down, because they know that they've been caught and that Glendora is going to sue them. Where the court, this is a frivolous paper, and it's more Rule 11 sanctions. And the lawyer for Natoa Anderson do not address all parties. They do not send the paper to all parties. It does not address no notice of motion and defendants' other fatal defects. It would just have to be brought in another court, Title 28 U.S. Code 472, against the cost and delay reduction plan mandated by Congress. And here is the conclusion. The issue is still New Mexico has to show New York and the District of Columbia how to do public access. Rule 11 sanctions must be imposed for frivolity and misrepresentation. I should have included Oregon there. Rule 56 must be applied for summary judgment. No dispute of facts. Rule 12b must be applied for no meritorious defense. Defendants failed to defend against the points in Glendora's cross motion. Dated White Plains, New York, July 9, 2001. Yours in truth. And it went to Natoa and Anderson and to their lawyer and to the lawyer for DCTV and to you, Glendora's TV audience, for the Center for Judicial Accountability, and for the United States District Judge Parker, courtesy copy, and to the clerk. And under penalty of perjury, Glendora declares she served the within 8-page reply on Pardon and Watson at their designated addresses. Service was by U.S. mail on July the 10th, 2001, Anno Domini. So I'm sorry this all got wrinkled, being carried into the bag. Here's another one that got wrinkled, and this is written to Karen Milton, who is the circuit executive. She used to be the clerk for the United States Court of Appeals for the Second Circuit. And it says Madsen has sent back this 372C1 3 times. This is a judicial misconduct complaint against Screwball Michael B. Casey, a United States District Judge in Manhattan. Madsen's letter, June 22nd, is not clear as to what is wrong with it. Glendora does not think anything is wrong with it. She called Madsen today, and he could not tell her what is wrong with it. And Madsen hung up. It is recorded on audio tape. Will you please tell Glendora what is wrong, if anything, and get this thing filed? Now, service list is Orrin Hatch, the House Judicial Committee, Meekum, the Administrator of U.S. Courts, the Center for Judicial Accountability, Glendora TV audience, that's you. Erwin Rommel, School of Law, that's Michael Brown. Senator Jeffords, and there's another one, A Matter of Justice. Now this McCasey complaint, he's a terrible failure. I read to you long ago. Here's Madsen's letter with his florid signature. Oh, and I sent him a copy of this petition against the whole Second Circuit and many of the people in the U.S. District Court, First District, and Madsen's been sued, see? Right there. Look at all these judges who were sued. Look at them. Good, good, good. Good for you, Michael Brown. Good for you, Peggy Deddick. Sue all these bums. Interesting paper. Okie dokie. Oh, I also sent it to Rehnquist, U.S. Supreme Court, I guess. Or was that the other paper? Okay. Now, let's see what we have. Let's see if we have any audio and any video. Folks, we have audio and we have video. So let's go through this pile of papers in preparation for editing tomorrow morning. This is July 11th, 1 week since July 4th. United States District Court, District of Vermont, Glendora Plaintiff versus Godfrey S. South and Mark South, defendants. Memorandum in outrage to the Chief Judge regarding this court's violation of rights, constitutional and statutory. 1. Refer to the letter on page 2. That's acumen. A clerk named Paul J. Dago says, I am writing in response to documents received here June 25th, 2001. Apparently you wish to file a case and proceed in forma pauperis. In order for this office to consider the IFP motion, it must be presented on a form that we have prepared for this purpose. I have read your complaint and consulted with the judge's law clerk. We notice that the listed parties do not reside in the state of Vermont, nor does appear any allegations as to events in the state of Vermont. Therefore, your complaint on its face indicates that U.S. Court for the District of Vermont lacks jurisdiction. If, after considering these defects of jurisdiction and venue, alleged they are. defects of jurisdiction and venue, alleged they are. And reading the statutes, you decide to resubmit your complaint, please contact me and I will send you an IFP form. Well, this is, okay. Glendora has a constitutional right to a United States District Judge. Don't you know that? Clerks are not judges. Clerks are not even suffragan judges. Read Article 3, the Constitution of the USA. Glendora has a constitutional right to an Article 3 judge. For these clerks to bungle this lawsuit as they have is abominable. Orrin Hatch, please note, House Judiciary Committee Senator Jeffords and Leonidas Ralph Meekum, please note. Clerks do not have jurisdiction judicial nor venue judicial. Nescience and irresponsibility hit a new nadir. How do you expect citizens to have respect for federal courts when you perpetrate such boners like this? And you will not even stand up for the American flag. What kind of citizens are you? Whatever happened to the Green Mountain Boys? During college summers, Glendora waitressed at the Equinox Hotel, Manchester, Vermont, and read about the Green Mountain Boys and read the historical markers along Route 7. Shame on you. You disappoint us. There is nothing wrong with the informa pauperis form Glendora submitted. It complies in every respect with 28 U.S. Code Section 1915 A, B, and C. By now, you should be ordering the U.S. Marshal to serve the complaint and summons on defendants and have the two forms numbered, 325, all filled out. Your IFP form cannot include any more nor any less than Glendora's. It was dumb not to send your form when you illegally returned all of Glendora's papers. Glendora is IFP, and you make her pay all this postage. Send your IFP form immediately. Read Moore's Federal Procedure. Vairo, V-A-I-R-O, is the author on jurisdiction, venue, and transfer. Note, case cannot be transferred to the Southern District of New York for two reasons, 28 U.S. Code Section 1404 and PACER. A transfer must be in the interest of justice, and there is no justice for Glendora in the Southern District of New York. The court did not serve all parties. Do your duty. Conclusion. July the 11th, 2001, Anno Domini, 1 week from July 4th, White Plains, New York, yours in truth, Glendora. Idiot. They have such a bunch of idiots in the United States District Courts. July 11th, 7 days after July 4th, 2001, United States District Court, District of Alaska. Glendora Plaintiff versus D.V. Benson et al., defendants. Rule 60B motion for relief from illegal order of June 25th by J.K. Singleton. If an IFP is denied, the case can proceed no further. Glendora's motion was to proceed without payment of fees. Since the motion for IFP was denied, the case cannot proceed further. Singleton cannot go on to dismissal. Singleton should have known he had to grant the IFP. Only then could he dismiss it. Dismissal is a nullity. Next is 28 U.S. Code Section 1404. A case cannot be transferred unless it is in the interest of justice. A glance by lazy Singleton shows there is no justice in the Southern District of New York for Glendora. He acts with no intelligence. Singleton violates all the rights the defendants do, constitutional and statutory. He will be dropped into the July who to sue. And I just sued him today. Singleton fails America, as do the defendants. Singleton makes false claims. All of the violations did not occur in New York. Philadelphia is not in New York. District of Columbia is not in New York. Salt Lake City is not in New York. So it is inter alia. Detroit is not in New York. Phoenix is not in New York. Singleton fails to serve all parties. Singleton did not enclose forms for notice of appeal. Singleton acts irresponsibly and returns and betrays his country. Rule 60B motion, Federal Rules of Civil Procedure, stops the clock on 30 days to appeal. We need courts, not old boys clubs. What do you think of Singleton, Orrin? Is he doing his job for the USA? These judges have no individuality. They all mimic each other. Wherefore, the court has erred and must first deny the IFP unless the court chooses to reform and do things right. Glendora must be relieved from this illegal dismissal. And then here's Singleton's crazy order written by a dumb, smart-aleck law clerk who knows nothing, has never had any experience on his first job out of law school. And Glendora's annotation thereof, and the list of the laws that Singleton broke, and the rights, constitutional end. And I have to file a 372C1 against Singleton for mental instability, conduct prejudicial to the effective administration of the business of the courts. Let's get these in order. The ladies' professional golf tournament is starting today. Well, it starts Thursday. Boy, it makes it very hard for the people who live near the Waikagill Golf Club. Very, very hard. All these tons of people, but I suppose it's good for the city. United States District Court, July 11th, Western District of New York, Buffalo. Glendora plaintiff versus Michael O'Rourke et al. Defendants. A Rule 60B motion for relief from illegal order by Elfin on June 15th. Here's another dumb United States District Judge, another dumb federal judge named John Elfin in Buffalo. Elfin cannot proceed until the IFP is granted. Ergo, the June 25th order is a nullity. The IFP motion was a motion to proceed without prepayment of fees. Since the motion was not granted, Elfin could not proceed to a transfer. Jackson, Mississippi is not in White Plains. Cleveland, Ohio is not in White Plains. Augusta, Maine is not in White Plains. Charlotte, North Carolina is not in White Plains. The case cannot be transferred to the Southern District of New York, ergo. Further, 28 U.S. Code, Section 1404, mandates that a transfer must be in the interest of justice. Glendora cannot get justice in the Southern District of New York, and a glance at Pacer will tell you that. Further, the Southern District of New York will not let Glendora file in the Southern District of New York. Glendora does not want to file in the Southern District of New York. It is a crooked court. She has personal knowledge, as do dozens of her associates. Elfin does shabby work. He is no patriot. Ergo, by Rule 60B, Federal Rules of Civil Procedure, the Elfin order is a nullity. The IFP must be granted and the case dismissed. Court has no redeeming features. Elfin did not send notice of appeal forms. Elfin did not serve all parties. Glendora will file 28 U.S. Code 372C1, judicial misconduct against Elfin for conduct prejudicial to the effective administration of the business of the courts. Yours in truth, Glendora. And here's his sloppy, shabby order, so-called, written by another stupid law clerk. Do you see what has happened to your court? God forbid anything should happen to you, that you would have to go to court because somebody stole your rights or stole your property or stole your money or whatever. You wouldn't get it because of these dumb judges. Not only are they dumb, they're crooked. They've sold their souls. July 11, 2001, 1 week since July 4th. Chief Judge, United States District Court, Eastern District of Pennsylvania, 609 Market Street, or 601, Philadelphia, New York. Dear dummies, Whatever made you think that Glendora versus Calabrese was filed in the United States District Court, Eastern District of Pennsylvania, that's Philadelphia, whatever made you think that? It was not. It was filed in the United States District Court of Arizona, and this was in January. Show Glendora any proof you have that she filed Glendora versus Calabrese in the United States District Court, Eastern District of Pennsylvania. After the mess that you made of Glendora versus Nickerson and Glendora versus Philbin, Glendora would never entrust another case to you. Service list: Orrin Hatch, House Judiciary Committee, a matter of justice; Michael Brown, Senator Jeffords, Meekum, the Administrator of U.S. Courts, Glendora TV audience, and the Center for Judicial Accountability. We're crazy nuts. The Bill of Rights Restoration Act Handbook. I'd like to have you read this whole book. I just can read you only one page at a time. I think if you asked Michael Brown for a copy of this, he'd give it to you. Experience, however, soon showed in what way they were to become just judges, the most dangerous, that the insufficiency of the means provided for their removal gave them a free hold and irresponsibility in office, that their decisions, seeming to concern individual suitors only, passed silent and unheeded by the public at large, that these decisions nevertheless become law by precedent, sapping